It's 1971. Jimmy Page strums out what would become rock's most sacred intro. But decades later, someone asks, did he really write it? Or did he steal it? Welcome to I Fought the Law, where rock and roll hits the courtroom. My name is Declan O'Lula, but folks call me Bebop. This is the story of perhaps the most famous rock song ever, Stairway to Heaven, and the questions surrounding its origin. I've called it Stairway to Litigation. I know. But what's a man to do? I had to call it something. Our story begins not in a courtroom, but in a smoky 1960s club. Randy Wolf, aka Randy California, guitarist for the band Spirit, writes a short instrumental called Taurus in 1966 or 1967. The song was first recorded in November 1967 and released in 1968 on Spirit's debut album. It opens with a descending scale. In 1971, Led Zeppelin releases the album 4, which went on to sell over 37 million copies. Included on that album is the 8-minute Stairway to Heaven. Although never released as a single, the song is a massive hit. Fans of Spirit make public comments about the similarities, but Randy, known as a humble and gentle man, does not take action or make a statement. There are maybe two aspects of similarity between these songs, but some big differences. The similar things are the chromatically descending bass line. But there's nothing original about that bass. It's so common that it has a name, the lament bass. Many Baroque composers used it, including J.S. Bach and Henry Purcell. Music has building blocks or commonly used phrases like any language. So the real question is, did Zeppelin copy Randy California's original expression, or just use a shared musical alphabet? Here's the first unusual fact in this case. Randy California didn't sue. In 2014, 43 years after Stairway was released, Michael Skidmore, trustee of Wolf's estate, sues Led Zeppelin. Randy California didn't really have a problem with the whole scene. It was the guy dealing with his deceased estate that had the problem. Skidmore claims that Led Zeppelin had access to Taurus. Led Zeppelin and Spirit had played shows together, and Jimmy Page even owned the debut Spirit album, a fact that Page freely admitted. But in court, access alone isn't enough. You also need to prove what lawyers call substantial similarity. What does that mean? This is a test used in copyright law. Essentially, it says that if an ordinary person, without any specific qualification or skill, listens to the two songs and says that the similarity between the two works is strong enough to conclude that the later song has copied the original. Courts consider both the quantity, how much was copied, and the quality, how significant is the copied material, when determining substantial similarity. Copying even a small but central part of a work can be considered substantial. The actual creative composition has to be similar, not just the idea. Ideas cannot be copyrighted, nor can facts, processes, ingredients, and other such information. In this case, we are not talking about the whole song, but rather that very famous intro. But this was the kicker. Was the intro to Stairway so recognizable because the song became huge in almost every country, or was it such a distinctive piece that a person would remember it without knowing the song? Clearly the former, especially when you sue on a song released 43 years before. Now here's another peculiar aspect of this case. The Taurus copyright was filed in 1967 under the old 1909 Copyright Act of America. That 1909 law didn't protect sound recordings, only the sheet music filed with the U.S. Copyright Office. So the jury could only compare one page of music, not the studio recordings. And those notes? They were mostly unoriginal, common scales, simple chords, not protected. This is why I'm not going to play you the music, because the music was not before the jury, and it would cost me a fortune in royalties. So after toing and froing in the lower courts of California, the case landed in the Court of Appeals for the Ninth Circuit. Although the appeal court disagreed with some of the more technical decisions made by the trial judge, it agreed with the two fundamental aspects of the trial judge's decision. 1. The trial judge was correct in relying only on the sheet music of the songs in question, as when the copyright was lodged, it was only in respect of the sheet music, as recordings weren't protected under the 1909 Copyright Act. The appeal court confirmed that recordings of the two songs were not admissible as evidence. 2. The correct test to apply was the substantial similarity test. Interestingly, the appeal court threw out something called the inverse ratio rule, which said that if you could prove substantial or extended access to the original, you played the song every day, for example, then you did not have to prove as many points of similarity. The appeal court said that this rule was not helpful at all and rather caused confusion, so they scrapped it. A very important consequence of this case. I don't agree with the appeal court in respect of allowing a comparison of sheet music only. They could have applied what lawyers call the mischief rule. When the wording of an act is producing a crazy result based on the specific facts before the court, a judge is allowed to use the mischief rule. This rule asks, what mischief was this act trying to avoid? The 1909 Act was made when recordings of songs was not available to the public. That happened about 30 years later. But if the 1909 Act was trying to stop people copying songs, which is the mischief, surely the court could have extended that to preventing the copying of sound recordings, as the subsequent Copyright Acts had already done, even though in 1909 this was not thought of by lawmakers. Opportunity lost, I think. Today, artists must prove two things: that the defendant, the one accused of copying, had access, and that they copied original protectable material. But the one does not impact the other. They are separate concepts, and so must be proved separately. So was it theft, or just rock and roll déjà vu? I say that common sense won out. Over a very long time, humans have made music, poetry, and songs. We are talking about millions of creations using, I think, a finite set of letters, notes, and chords. There have to be similarities amongst these creations, particularly in popular music, which seems to follow trends. Musicians readily admit to nicking an idea here or a phrase there, but usually as a trigger to get the creative juices flowing. And that's okay, we all need inspiration. What must be protected is that spark of genius, that flash of inspiration, that hook that makes that protected section unique. I'm Bebop Olula, and I'll see you next time on I Fought the Law. Coming up on the next episode of I Fought the Law, did Jimmy flash his willy? Until then, goodbye.